So I want you to imagine for a second that you are stuck in a DMV line. And this line, it hasn't moved in 2 years.
Oh, that sounds like an absolute nightmare.
Right. I mean, you're exhausted, you're frustrated, and there is just absolutely no end in sight. But then suddenly, this VIP lane just opens up.
Okay, I'm listening.
And it's completely free. Plus, it actually guarantees you'll be out of there in exactly 60 days.
Wow, that is quite the pitch.
Yeah, but there's a catch. The only catch is that you have to, voluntarily hold hands with the exact person you are actively suing in order to use it.
You know, that visual, it perfectly captures the absolute absurdity, but also the brilliance of what we are looking at today.
It really does. Because historically, I mean, the legal system, really any legal system, it's built on adversarial combat, right?
Oh, absolutely. You stand in your line, your opponent stands in theirs, and you just wait for a judge to declare a winner and a loser. It is definitely not built for hand-holding.
Exactly. Which brings us to our mission for today's deep dive. We are exploring a super fascinating legal experiment that is playing out right now in Uganda.
Yeah, it's a huge shift.
We're looking at the brand new 2026 Judicature or Court-Annexed Mediation rules, and these were just gazetted, which, basically means they were published in the official government record and made the binding law of the land.
Right, and they just went into effect in March of 2026.
Yep, March 2026. So we've pulled together a bunch of sources for you: official rule documents, backlog statistics, expert legal commentary, and even some regional comparisons.
There's a lot to unpack here.
There really is.
Yeah.
We are going to uncover how Uganda is attempting to solve this monumental judicial crisis. And the crazy part is they aren't doing it by adding more judges or strict mandates.
No, they're doing the exact opposite, really.
Right. They are making conflict resolution entirely voluntary and entirely free. But, before we get into how this new VIP lane actually works, I need you to explain the scale of this traffic jam.
Well, the traffic jam is, it's massive.
Yeah, because I saw some mentions of the backlog in our sources, but can you just put the actual numbers into perspective for us?
Yeah, I mean, the scale is honestly almost difficult to comprehend. As of early 2026, Uganda has over 167,000 pending court cases.
Wait, 167,000 across all their courts?
Across all their courts.
Yeah.
And out of those pending cases, about 28%, so that's roughly 46,500 cases, are officially classified as backlog.
Okay, what exactly makes it a backlog? How old does a case have to be?
In their system, a case officially becomes a backlog when it is older than 2 years. Just sitting there, unresolved.
2 years. Wow. But I have to assume that number isn't just static, right? With a growing population and economy, are they just kind of treading water or what?
Actually, they are losing ground. Between 2015 and 2025, the national caseload grew at an annual rate of about 4%.
Oh, so it's just compounding.
Exactly. The system is fundamentally overwhelmed.
Yeah.
And, it's not just a matter of citizens waiting around for a piece of paper to be stamped.
Right. There's a real-world impact.
A massive one. There is a huge, tangible economic cost to this gridlock. The total value of unresolved civil disputes locked up in this backlog is a staggering 14.2 trillion Ugandan shillings.
Wait, 14.2 trillion? With a T.
With a T. That is money that is completely frozen.
That is insane. I mean, that represents businesses that can't operate, right?
Yep. Land that can't be developed, inheritances that can't be accessed, just frozen.
Okay, let's unpack this for a second. Because if there is almost 15 trillion shillings locked up in court, just freezing the economy, why didn't the old rules work?
That is the million or, I guess, trillion-dollar question.
Right. Because Uganda had mediation rules before this, didn't they? The 2013 rules.
Yes, they did.
And under those old rules, mediation was actually mandatory. Every civil case was supposed to go through it.
They were supposed to, yeah.
So it seems deeply counterintuitive to me that forcing people into mediation didn't clear the pipes, but somehow making it completely voluntary will? How does that make sense?
What's fascinating here is that mandates, when you don't have the resources to back them up, they simply become administrative checkboxes.
Just a hurdle to jump over.
Exactly. Under the 2013 rules, the court would order a referral at an early stage. But as Justice Zija, who is a key figure in the Ugandan judiciary, as he noted, very few cases were actually resolved this way.
Because people just didn't care?
Well, you have to look at the psychology of the courtroom. If you force two curious parties into a room without highly trained, available mediators,
right,
and without a cultural belief that the process even works, the lawyers will just go through the motions.
Oh, I see. They just show up, stare at each other, and say, well, we tried.
Yep. They check the box, declare that the mediation failed, and default straight back to the traditional trial track.
Yeah.
You just cannot mandate a behavioral shift if the infrastructure to support it doesn't exist.
That makes total sense. I mean, if you force me to negotiate but don't give me a capable referee, I'm just going to stare at the other guy until the clock runs out.
Exactly what was happening.
But okay, how do we know this new voluntary approach isn't just going to result in zero participation? If people are mad at each other, why would they volunteer?
So we actually have concrete proof of concept from their 2025 pilot data.
Oh, so they tested it first.
Yeah, before these new rules were fully codified, they tested the waters.
Yeah.
Between January and November of 2025, even with pretty limited resources, mediation resolved over 5,200 cases.
Wow, just in that short window.
Yeah. And that activity actually caused the overall pending backlog ratio to drop from 26.3% to 24.2%.
Wait, so the backlog started declining even while new filings were rising.
Exactly. It was actually making a dent.
And I noticed in the sources, this wasn't just like tiny, small claims court stuff, right? They were tackling some massive disputes.
Precisely. The pilot data points to this monumental 1.3 trillion shilling land dispute involving the Uganda kingdom.
Over $1 trillion shillings in one case.
Yes, and it was settled entirely through mediation.
That is wild.
It really is. And that specific case proved to the legal establishment that incredibly high-value, highly complex cases could completely bypass the backlog if the parties were brought to the table effectively, rather than forced into a performative hurdle.
Right, so they saw this massive $1 trillion shilling land dispute actually get resolved without a trial.
Yeah, it was a huge turning point.
So realizing that the mandatory 2013 approach was just creating a bottleneck of noncompliance, the 2026 rules completely flipped the script.
They overhauled it.
They decided to change how mediation is initiated and funded to get people in the door willingly. So how exactly does this new mechanism work?
Well, the absolute foundational shift is voluntary consent. You just cannot be forced into it anymore.
So it's totally up to the parties now.
100%. Under the 2026 rules, mediation only happens if all parties agree. You can voluntarily refer any civil matter at literally any stage before the final judgment.
Okay, and who actually does the mediating?
You can choose your own mediator from an accredited list, or even bring in a mutually agreed upon third party if you want.
There's actually a really unique provision here that caught my eye in the research. Even a judge can serve as the mediator if everyone consents.
Yeah, that is a highly unusual and powerful tool. A judicial officer can literally step down from the bench and mediate your dispute.
But doesn't that create a conflict of interest? Like, if the judge knows all your secrets from the mediation?
Well, the rule establishes a strict firewall to prevent exactly that.
Okay, how does the firewall work?
If that judge tries to mediate the dispute and the mediation fails, meaning the parties just can't reach a compromise, that judge must withdraw from adjudicating the case entirely.
Oh, wow, so they're just off the case.
Exactly. They cannot go on to preside over the trial. It preserves the absolute neutrality of the trial process while giving parties the option of having a highly authoritative figure help them find common ground.
That is incredibly smart. So what does this all mean for the everyday person who is actually stuck in the system? Because, I mean, the biggest hurdle usually isn't just time, it's money, right?
Absolutely. The financial barrier is huge.
And this is where the 2026 rules do something that seems almost unheard of. The judiciary now pays the accredited mediators.
Yep, the state pays.
So litigants pay zero fees. The state is essentially picking up the tab for a heavily structured, expert-guided negotiation session.
Exactly. It's fully subsidized.
But you only have 60 days to figure out your differences before you get kicked back into that 2-year waiting line.
Right. And if we connect this to the bigger picture, the state teaching is a revolutionary step for access to justice.
Because it levels the playing field.
Completely. Under the old regime, parties typically had to pay the mediator's honorarium out of pocket or petition these court registry funds, which was complicated.
I can imagine.
For poorer litigants, that was a massive, sometimes insurmountable barrier. By eliminating that fee, the government is explicitly aiming to help those with smaller cases or limited means.
So it's not just for the wealthy anymore.
Right. It shifts the entire paradigm of ADR, which, stands for Alternative Dispute Resolution. Instead of ADR being a luxury for wealthy corporations who can afford private arbitrators, it suddenly becomes a public utility.
That's a great way to put it, a public utility. But I mean, the government surely isn't just writing a blank check for infinite mediation, right? How do they keep people from abusing this free ride just to stall their cases?
That is where the structural rigor really comes in. You mentioned the 60-day clock earlier.
Right, the 60 days.
It is a strict maximum timeline from the moment of referral. You don't get endless extensions. And to enforce that, there is a whole new layer of administrative oversight.
What kind of oversight?
Mediators now face a rigorous 30-day accreditation process managed by the Chief Justice. They can't just be anybody.
Okay, so quality control.
Exactly. But more importantly, the mediators have to submit monthly performance reports. They have to file attendance sheets and progress reports after every single session to the Case Management Committee.
Wow, so they are heavily monitored.
Very much so. If a mediator is dragging their feet just to collect more state fees, the Chief Justice can suspend or revoke their accreditation instantly.
Okay, so the state is paying, but they are keeping a very close eye on the clock.
Precisely.
Now, there is another really crucial element to this VIP lane that we need to unpack, the ironclad confidentiality.
Oh, this part is so important.
Because, think about it, if I'm going to sit down with someone I am actively suing, and I have to admit where my case might be weak in order to reach a settlement, I need to know my words won't be weaponized against me later.
Right. The 2026 rules strengthen this significantly to create actual psychological safety in that room.
How do they do that?
Before any sessions even begin, the mediator must have all parties sign a formal confidentiality and inadmissibility agreement.
So it's legally binding from minute one.
Exactly.
Yeah.
And it explicitly dictates that all oral statements, written statements, documents, and proposals made during mediation are entirely privileged. They absolutely cannot be used in a future trial.
Our sources even noted that it explicitly bars parties from using anything said in the room for a defamation suit.
Yes, that's a very specific protection.
I mean, you literally can't sue someone for slander just because they insulted you while trying to negotiate a settlement. That's how protected the room is.
Right. They want you to be able to speak freely.
But it's not a total black box, right? I mean, there have to be mandatory exceptions for public safety.
Oh, definitely. There have to be. The rules carve out very precise mandatory reporting exceptions. Disclosures involving child abuse or sexual offenses are not protected by confidentiality.
Okay, that makes sense.
If a mediator hears about an active crime of that nature, they have a strict legal duty to report it. ADR experts have highlighted this as a major upgrade, actually.
Really? Why is that an upgrade?
Because it is much more precise than the vague 2013 guidelines were. It enhances the protection for civil negotiation while still preserving the duty to report serious criminal matters.
It sets very clear boundaries.
Exactly.
You know, to really understand how radical this free, voluntary approach is, I want to look at what Uganda's neighbors are doing, because when you examine the regional landscape, Uganda seems to be carving out a completely unique path.
They absolutely are an outlier.
Let's talk about Kenya, for example.
Yeah, look at Kenya.
Huh.
Under their 2022 civil procedure rules, they also utilize a strict 60-day timeline. So that part is similar.
Okay, but what's different?
In Kenya, the screening is mandatory. All civil cases are automatically screened for mediation suitability, and parties can only opt out if both sides request it.
Oh, so you don't really have a choice about the screening.
Right. And furthermore, the parties have to pay the court-enlisted mediators out of their own pockets.
Yeah, so there's that financial barrier again. Then you have South Africa. Specifically, I was looking at the Gauteng High Court Directive, which feels incredibly aggressive compared to Uganda.
It really is.
They mandate a 30-day pre-trial mediation process for all civil trials. You do not have a choice. You must go through it.
Yeah, South Africa takes a very firm hand there. And consider Nigeria as well, which honestly operates as a bit of a patchwork depending on the state.
Like different rules for different areas?
Exactly. Lagos, for instance, operates under the Multi-Door Courthouse Act. A multi-door courthouse is essentially a legal hub that offers various dispute resolution doors like mediation, arbitration, or traditional litigation.
Okay, that sounds pretty innovative.
It is, and they heavily encourage mediation. But again, it is mostly party-funded. Litigants pay the mediators, often from their initial court deposits.
So Uganda is really standing alone here.
Very much so. Uganda's standout feature in this entire African landscape is that it is the solitary system combining a fully voluntary opt-in structure with completely state-funded mediators.
Okay, but here's where it gets really interesting to me. We're talking about removing mandates, offering free mediators, and wrapping things up in 60 days. Won't the lawyers absolutely hate this?
That is the elephant in the room, isn't it?
I mean, the entire traditional business model of law, the whole system of billing hours, it's built on protracted combat.
Right, dragging things out.
If lawyers are relegated to taking a back seat while their clients do the talking and cases wrap up in 2 months instead of 2 years, aren't they losing control and just a massive amount of revenue?
Your suspicion is completely valid. The new rules explicitly redefine the role of advocates. Lawyers must shift from being these combative gladiators to taking on more of an advisory role.
Which has to be a huge ego hit for some of them.
Oh, without a doubt. The rules dictate that the client is supposed to lead the session. The lawyers are just there to advise in good faith, ensure their client actually shows up, and facilitate the compromise.
So they aren't the stars of the show anymore.
No, they aren't. And there is a very real risk of cultural resistance from the bar because of that. Lawyers who are accustomed to adversarial practice, who literally make their living filing endless procedural motions, they might try to sabotage the process.
So how does the Ugandan judiciary incentivize the lawyers to actually play along? Like, how do you get them to advise their clients to take this route if it hurts their bottom line?
Well, by appealing to a totally different economic model. Volume.
Ah, okay. Make it up in volume.
Exactly. Moving cases faster means lawyers can handle a much higher volume of files.
Right.
Instead of babysitting a stalled case for 5 years, attending pointless hearings, and struggling to collect fees from exhausted clients.
Which happens all the time.
They can close the file in 60 days, get paid their settlement commission, and take on 3 more clients.
That makes a lot of sense from a business perspective.
But beyond the economics, the 2026 rules offer a crucial psychological safety valve for lawyers that simply did not exist before.
What's that?
It's called the set-aside rule.
Okay, I want to push back on this set-aside rule for a second, because when I was reading the sources, it felt, I don't know, kind of like a paradox.
It definitely seems that way at first glance.
Right, because under the old 2013 rules, once you signed a mediation agreement, that was it. It became a consent judgment, and there was a blanket no appeal rule, which honestly sounds terrifying.
It was very rigid.
Now, under the 2026 rules, a disgruntled party can seek leave to vacate that consent order on very narrow grounds: fraud, mistake, illegality, or collusion.
Correct.
But wait, you just told me everything said in that mediation room is strictly confidential.
Yes, it is.
So if the room is a black box, how on earth do you prove fraud or collusion to get a bad settlement set aside? Doesn't the confidentiality block you from proving the fraud?
You've hit on the exact tension that makes this rule so delicate. It is a paradox, but it works through a very specific legal mechanism.
Okay, walk me through it.
The confidentiality protects the negotiation chatter, the offers, the admissions of fault, the apologies. You can't use any of that.
Right.
But the final settlement document itself and the external facts that it relies on, those are not immune from reality.
What do you mean by external facts?
For example, let's say during mediation, one party signs a binding agreement claiming they only have one bank account, and the entire settlement is based on that fact.
Okay, makes sense.
But 6 months later, the other party discovers 3 hidden offshore accounts.
Oh, I see.
Right. The fraud wasn't just a statement in the room. It was a material deception that formed the basis of the signed contract.
Got it.
The set-aside rule allows you to challenge the validity of the contract based on those external, verifiable lies, without ever needing to quote who said what during the session.
That makes total sense. I mean, think about it from the perspective of you, the listener. Imagine signing a massive life-altering contract, knowing that even if the other person completely lied about their assets, you could never, ever back out.
You would never sign it in the first place.
Exactly. By adding this narrow window to challenge the agreement based on fraud, it balances finality with fairness. It actually gives lawyers the confidence to walk their clients into the room.
It removes the absolute terror of the irreversible mistake. When lawyers know there is a safety net against blatant deception, they become much more comfortable guiding their clients toward compromise, rather than just clinging to the safety of a trial.
Okay, so the state is paying for it, the rules are perfectly drawn to balance fairness and speed, and the lawyers are being given tools to play nice.
That looks great on paper.
It does. But launching a system this ambitious across an entire country requires some serious logistical gymnastics. It's like throwing a massive free music festival, but forgetting to hire enough security or build enough entrance gates.
Yeah, the logistics are daunting.
If the government doesn't accredit enough mediators fast enough, that 60-day VIP lane just becomes another parking lot. So what are the actual roadblocks to pulling this off by 2027?
Well, the implementation timeline they have set is incredibly aggressive. The rollout is scheduled from May to December 2026.
That's practically no time at all for a whole nation.
It's extremely fast. They are attempting to conduct concurrent public awareness training, a massive mediator accreditation drive, and pilot rollouts in selected high-load courts, all at the exact same time.
Wow. What's the biggest hurdle?
The first major tangible roadblock is IT integration.
Okay, yeah, I saw mentions of the CCAS and ECCMIS systems in the research. What exactly are those, and why are they a bottleneck?
Think of CCAS and ECCMIS as the nervous system, or like the operating software of the Ugandan courts.
Like their digital filing system.
Exactly. They are the digital case management systems that track every single file. The problem is, they were coded and designed for traditional trials.
Oh, I see where this is going.
Right. They track filing dates, hearing dates, and trial judgments. They are not currently programmed to track a strict 60-day mediation window, or to flag partial settlements, or to process these new monthly mediator performance reports.
So the software literally doesn't know how to handle the new rules.
Exactly. The entire national IT infrastructure has to be updated and recoded so that the case management committee can actually see if the system is functioning.
That sounds expensive. And speaking of money, there is the reality of the funding. We discussed how revolutionary it is that the state is paying the mediators, but a promise written in a gazetted rule is very different from cash clearing a bank account.
The funding risks cannot be overstated here. The judiciary has stated they will remunerate accredited mediators, but court budgets need to actually allocate those funds in real time.
They need actual line items for it.
Yes. They need dedicated budgets for mediator fees, for the administration of the ADR oversight units, and honestly, even just for physical mediation facilities at the courthouses.
Right, you need actual rooms to put these people in.
Exactly. If the money doesn't flow quickly and reliably, mediators will simply stop taking the cases, and the entire voluntary system stalls.
Which brings us to the human element. If there aren't enough accredited mediators to handle the volume of people wanting this free service, the system instantly bottlenecks.
That is exactly why the Case Management Committee's monthly tracking is so vital. They have to ensure that the accreditation drive processes applications within the mandated 30-day window, just to build up a robust roster of experts.
So they need the supply to meet the demand.
Right. But there's also a deeper cultural risk here that goes beyond just the lawyers or the IT guys.
You mean the citizens themselves, the people actually suing each other?
Yes, society at large.
Right.
The sources note that public awareness of mediation is still very, very low in Uganda.
People just don't know it's an option.
Or they don't trust it. There's a deep-seated cultural preference for traditional litigation.
They want their day in court.
Exactly. When people feel wronged, they want vindication. They want a judge in a robe to declare them right and the other guy wrong. Or, conversely, they rely on negotiation through very informal patronage and power dynamics.
So it's hard to break those habits?
Very hard. If the public culture doesn't shift, if everyday people don't trust this structured, non-adversarial process, even free mediation won't save the docket. Judiciary officials, like Justice Abodo, for instance, have stressed that nationwide public sensitization campaigns are going to be absolutely vital to overcoming the psychological barrier.
So let's bring all of this together. Uganda is looking at a mountain of 167,000 cases, with a backlog trapping 14.2 trillion shillings in economic limbo.
A staggering problem.
And their solution is incredibly counterintuitive, yet profoundly logical. They are attempting to clear this massive jam by treating the public not as subjects to be ordered around with strict mandates, but as partners in dispute resolution. They are removing the financial friction by having the state pay. They are removing the coercion by requiring absolute voluntary consent. And they are relying on strict 60-day timelines, ironclad confidentiality, and highly trained accredited mediators to make the alternative far more attractive than the trial.
It really is a paradigm shift in statecraft. And, there is a broader relevance here for anyone listening.
How so?
Well, whether you're navigating a business dispute, managing a team, or just looking at how broken systems in your own life can be fixed, there is a profound lesson in Uganda's approach.
Right.
Sometimes the instinct when a system is failing is to clamp down harder, to issue more mandates, to force compliance.
Yeah, that's usually the go-to move.
But what we are seeing here is the radical theory that removing a mandate, taking away the financial barrier, and offering a highly structured, expertly guided alternative actually achieves much higher compliance than forcing people's hands. When you give people agency, they are vastly more willing to find a compromise.
It's a fascinating experiment in human behavior, which leaves me with a lingering question, something for you to chew on after this deep dive.
Well, I like a good lingering question.
If a government paying for private mediation is the secret to clearing public court backlogs, could this state-funded compromise model be applied to other gridlocked public services?
That's a really interesting thought.
And if the state is buying your compromise, who really owns the justice at the end of the day? Something to think about the next time you find yourself in a stubborn disagreement or stuck in a line that just won't move. Thanks for joining us on The Deep Dive.